The Ohio Mock Trial Program is a statewide educational competition designed to educate students regarding the law and the Constitution, as well as build important critical thinking, public speaking, and interpretation skills. Each year, a committee of volunteer attorneys create an original case based upon a constitutional issue. Professional developments and other resources are offered to teachers to help them prepare to use this case in the competition. During competition, each team will have the opportunity to argue their case as both the prosecution and the defense. Each trial consists of 4 main elements: opening statement, direct examination, cross-examination, and closing arguments. You'll see an example of each of these elements here today. In the case you'll be seeing today, Phillips High School agrees to license the naming rights to its field to a large multinational corporation. In response, students organize protests, post flyers, and take actions both in the school and near the field. In response to this, Phillips High School installs additional security cameras, searches student lockers, and files an action to remove the students from the field. The students counterclaim, asserting that the school district has violated their First and Fourth Amendment rights. The first trial element you'll see today is opening statement. To tell you a little bit more about that, we're joined by Westerville North Academic Advisor, Zach Wilkerson.
The opening statement is the first thing that a judge is going to hear in the trial. So it's very important that the attorney engages their audience and also establishes the major theories they have for the case. They should start off with a theme, a 1 or 2 sentence explanation of what they think the case is about. They should also give the court a version of the facts of the case that is favorable to them. Finally, it's very important that the attorney establishes what they have to prove in the trial in order to win, and the major evidence they intend to provide to do so.
May it please the court. Your Honors, the peaceful learning environment at Phillips High School has been disrupted. When that process is disrupted, it is vital that the learning environment of the school is restored. This is a case about reasonable actions in unreasonable circumstances. The protests by Occupy went far beyond ordinary student protests. When the deal was announced, most people in the community supported it, except for a small number of students at Phillips High School. The principal tried to explain to these students why the school so desperately needed the money, but the students wouldn't listen. Instead, they formed Occupy and began protesting. Occupy students vandalized school property, had shouting matches in hallways, put up leaflets that violated school policy, and at one point, physical violence almost took place. Your Honors, to meet our burden of proof, we must prove 4 things. First, we will show that we have a strong likelihood of success based upon the merits of the underlying claim. We will show no Fourth Amendment rights were violated, as the school had reasonable suspicion and recovered evidence that the students violated school policy. We will show no First Amendment rights were violated, as the students' protests were disruptive to school functions and were non-curriculum related. Assuming arguendo, we will show that if Occupy was curriculum related, then the school has the right to regulate speech. Second, we will show that by granting the plaintiff's TRO, it will not prejudice third parties. Third, we will show that the students' protests will irreparably harm the school, and the public interest will be served if the plaintiff's TRO is granted. Your Honors, the students broke school policy and the principal simply enforced it to preserve, protect, and defend the learning environment at Phillips High School. The principal took reasonable actions in unreasonable circumstances. Therefore, we respectfully request that you deny the defense restraining order and grant the plaintiff its temporary restraining order. Thank you.
The direct examination is the portion of the trial where attorneys question witnesses who are friendly to their side of the case. The attorney should ask open-ended questions and should be genuinely engaged in what the witness has to say. The witness should really be the star of the direct examination. They should understand the facts of the case and lay them out in a way that is friendly to their side of the trial. Objections can be made anytime an attorney believes that a question or testimony violates one of the Ohio Mock Trial Simplified Rules of Evidence. When an attorney wants to make an objection, they should stand, say objection, and then state the grounds for their objection. Then if the judge wishes, they can allow the other side to respond as well.
The defense calls Jesse Springfield to the stand. Could you please introduce yourself to the court?
My name is Jessie Springfield. I'm 17 and I'm a junior at Phillips High School.
Why are you here today?
I'm representing 5 of the members of Occupy whose voices are being silenced by the school.
Could you tell us what Occupy is?
We're a group of students that are protesting for our constitutional rights to have a say in our school and its decisions. It's a beautiful thing, really. We're taking what we learn outside the classroom and actually putting them to practice.
Did Principal Gomez give Occupy a time, place, and manner for its protest?
No, she only told us that we couldn't protest, which of course wasn't an option.
So does that mean that you stopped protesting?
Of course not. We still needed our voices to be heard. So we had an emergency meeting that night outside the football stadium.
What happened at that meeting?
At that meeting, we came up with this idea called Tent City. And it was really exciting. I thought we could do something great for the community.
What's Tent City?
It's an occupation of Freedom Field. Well, it's more symbolic because we weren't actually on the field, but it was still pretty cool. And we posted signs protesting the NFC deal, which hopefully some of them got the community's attention.
Speaking of the community, who came to Tent City?
A bunch of people, reporters and people who supported us and parents and our history teacher, Mr. Chen. And a few cops walked through at some point taking pictures, but they didn't talk to us.
Was it your intention for Tent City to disrupt NFC's construction?
Our intention wasn't to physically stop the construction because it was a symbolic protest. Our intention was just to get the school to notice us and understand that students deserve a say in things that affect them like this.
So did Occupy block entrance to the football field?
No, we did not.
Did Occupy vandalize any of NFC's equipment?
Of course not. That would go against Occupy's core values.
What was the atmosphere of Tent City like?
It was really exciting, and it was also pretty laid back because everyone was just hanging out and doing their homework and making signs.
Finally, was Occupy disruptive to education at Phillips High School?
Objection and proper expert opinion.
May I respond, Your Honor?
You may.
This question doesn't call for expert testimony. I'm simply asking the witness about her perceptions of education at Phillips High School.
Your Honor, may I respond?
You may.
Your Honor, this is asking for expert testimony because as to whether the education was actually disrupted, it goes to Tinker v. Des Moines.
Objection sustained.
Was your education disrupted by Occupy?
Not at all. If anything, it was the opposite. So much debate and discussion came up from this deal, and it was really exciting to actually take what we were learning in our class and apply it to our lives.
Thank you, Your Honor. No further questions.
Cross-examination is the portion of the trial where attorneys question witnesses from the opposing side. The goal of cross-examination is to damage the opposing side's case and the witness's testimony. On cross, the attorney should be the star. They should ask closed-ended questions that ask for a yes or a no and prevent the witness from adding additional information. The witness should do their best to maintain their testimony from direct and maintain their case in general.
Let's talk about why you're here today. You and 4 other Occupy members' lockers were searched, correct?
That's correct.
And so were your backpacks, right?
Yes,
Now, you say this was without your consent, correct?
it was.
You are familiar with the Phillips High School Student Handbook, right?
I believe so.
Your Honor, let the record reflect that I'm showing opposing counsel a clean and unmarked copy of Exhibit A. May I approach the witness?
You may.
This is select provisions of the Phillips High School Student Handbook, correct?
Yes.
Please read along silently as I read the second paragraph under search of a student's personal property by school authorities. The principal or her designee may search your backpack or purse without your consent or your parents' consent if they have a reasonable suspicion that you're breaking the law or violating a school rule. Did I read that correctly?
You did.
Now, let's talk about why your locker was searched. Your locker contained Occupy flyers, right?
Because we weren't allowed to hang them up anymore, yes.
But you had been hanging these flyers up all around the school, right?
Before we weren't allowed to anymore, yes.
But you knew before you hung them up that they were violating school rules, right?
The flyers themselves weren't violating school rules, no.
But you knew that you had to get them approved by the principal one day in advance, didn't you?
We did.
And you didn't do that, correct?
In order to avoid censorship of our flyers, yes.
So you purposely didn't do that, right?
To avoid censorship, yes.
So you broke that school rule, correct?
That one minor school rule, yes.
Now, the flyers did not have an individual student's name on them, correct?
It was unnecessary, no.
Occupy meets on school property, right?
We met a few times in unused classrooms, yes.
In order to organize protest, Occupy meets in the school cafeteria, right?
A few of us have lunch together, yes.
And this is during school hours, right?
Yes.
Occupy wasn't approved by the principal, was it?
No, we were not.
Occupy isn't registered as a student group, is it?
No.
In fact, Occupy didn't even attempt to register, right?
No, we did not.
Now, you would agree that you wanted your protests in the school to move forward, right?
Well, of course, yes.
And you want them to move forward even if they break school rules, right?
I care more about the Constitution and my rights than a few minor school rules, yes.
So that's a yes?
Yes.
No further questions.
The closing argument is the last thing a judge will hear in a trial. So it's very important that the attorney ties all the elements of the case together. They should go back to their theme from their opening that they've threaded throughout the rest of the case. And they should also apply the facts of the case to the law so that they can prove to the judge that they deserve to win their case based on the merits that they have presented to the court.
May it please the court. This is a case about reasonable actions in unreasonable circumstances. The actions taken by the school were taken to preserve and protect the learning environment. If rules are not enforced, the result will devastate a school, its students, and an entire community. As you have heard, the actions taken by the defendants left Principal Gomez with no choice but to take reasonable and lawful actions. At the beginning of this trial, my co-counsel told you that we had to prove 4 things in order to meet the requirements of our temporary restraining order. We have met that burden. First, we have proven that we have a strong likelihood of success on the merits of the underlying claim because there were no constitutional violations. No Fourth Amendment rights were violated in today's case. In New Jersey versus TLO, the U.S. Supreme Court held that the search of a student's personal belongings by the school without the student's consent does not violate their Fourth Amendment rights. Instead, schools have a relaxed standard on searches and seizures. Schools only need reasonable suspicion that school rules are being broken and/or laws are being violated to perform a search. We have proven that the school had reasonable suspicion. Officer Casey Mancuso testified that Occupy printed and distributed leaflets on school property. Occupy met in school classrooms where they conspired to engage in illegal activity. Principal Gomez told the court that in doing so, Occupy broke several school rules. In addition to this, no First Amendment rights have been violated. Board of Education versus Mergens establishes that the school has the right to regulate the speech of a non-curriculum-related group. Mergens clearly held that if the group's subject matter is not taught in class, participation in the group is not required. The group's subject matter does not concern the student body as a whole, and it does not result in a school credit. It is non-school sponsored. We have proven that Occupy meets the non-curriculum-related standard. Principal Gomez has testified that Occupy is unregistered and non-curriculum-related. Therefore, Mergens allows for Principal Gomez to regulate Occupy's speech. Rules exist for a reason, especially rules in our schools where their purpose is to educate and manage any distractions to learning. Reasonable actions were taken so that one group cannot take over an entire school and destroy a community. Principal Gomez simply had no other options. Therefore, we, the plaintiff, respectfully request that you deny the defendant's restraining order and grant the plaintiff's. Thank you.
Mock trial is an incredibly rewarding experience as an educator. It's amazing to see students grow in terms of their thinking, their public speaking skills, their writing skills, their reading skills, as well as the camaraderie that students get from the experience in becoming a team. But the most important part is that mock trial teaches students to believe in themselves, to believe in what they can do, and the skills they learn from mock trial will be useful to them no matter what they end up doing with their lives.